The Premack Virtual Online Law Office presents attorney Paul Premack with this week's legal column, published in the San Antonio Express News on mysa.com and on our website at www.premack.com. This week's topic:
Dear Mr. Premack, I was notified by an attorney that he was hired by 3 of 5 siblings to probate my mom's will. If I do not agree with hiring this attorney, what are my options? Signed, JMC. According to the Texas Probate Code, a will can be offered for probate by the nominated executor or by any interested party. Any of your mother's children would likely qualify as an interested party. But when an interested party hires an attorney to file an application for probate of the will, they are limited to asking the court for 2 things. 1, to accept the offered will as the last will of the decedent, and 2, to empower the nominated executor to handle the estate's affairs. It would be truly unusual for an attorney to accept multiple clients, 3 of 5 siblings, in a probate matter. Generally, attorneys like to have one clearly defined client to whom they are responsible. Again, generally in a probate proceeding, that client is the nominated executor of the estate. Thus, it may be that 3 of 5 siblings concurred in hiring this attorney, but the attorney should have identified only the nominated executor as the actual client. What can you do? First, if you have legal grounds to do so, you could contest the will. A contest does not stop that attorney from representing his client, so it does not really achieve your goal. Second, you could agree that the will is acceptable, but that the sibling nominated as executor should be disqualified. You could hire your own attorney to prove that the nominated executor does not meet the legal standards for serving in that role. Again, this does not stop that attorney from representing his client and does not really achieve your goal. When you say you, quote, do not agree with hiring of this attorney, close quote, what is your exact objection? Have you had negative experiences with that attorney? Do you feel that attorney charges too much? Do you have a friend attorney you wanted the family to hire for the probate? Your motives for not wanting this attorney may or may not sway your siblings if you speak to them. If you can convince them that you have sound reasons for wanting a different attorney, perhaps they will ask this one to withdraw and substitute other counsel more to your liking. Failing that, the decision really belongs to the person nominated as executor. You just need to go along for the ride and let the legal process do its job. Dear Mr. Premack, my father passed away a couple of years ago without a will. My parents were divorced at the time, and he was survived by his second spouse. Is it mandatory for his estate to be probated, and who should file? Signed, TF. According to the Texas Probate Code, when a person dies without a will, the probate administration can be initiated by, quote, any interested party. Sound familiar? When there's no will, there is no nominated executor, so it is logical that the application would be submitted by someone who was interested in becoming administrator of the estate. The Probate Code sets up a priority list of people who may serve. Top priority goes to the surviving spouse if she desires to serve. If not, the next priority goes to next of kin in order of descent, that is, children first, grandchildren second. If none of them apply, then a creditor seeking payment of a debt may apply to be administrator. If no creditor applies, then, quote, any person of good character residing in the county, close quote, may apply, and failing that, any, quote, other person not disqualified by law may apply. Probate of the estate must be opened before the general 4-year statute of limitations runs out. Since it has been a couple of years since he died, you're likely still within the allowable period. But if he has no remaining assets and no debts, then probate is most likely unnecessary. However, since it has been a couple of years, it's unlikely that you want to probate to clear his debts. They would have forced you to act more promptly. So I assume your father owned some land or other asset which you now seek to have legally distributed. If so, probate is necessary.